For nearly a century, professional baseball has enjoyed a court-made exemption from antitrust laws. But does that exemption apply to other sports? A federal judge took a slapshot at professional hockey in Philadelphia World Hockey Club versus Philadelphia Hockey Club. The National Hockey League was created in 1917 with 2 Canadian teams. By the end of World War II, the league had 6 teams. The league expanded to 12 teams in 1967, and 2 more joined in 1972. The NHL was the only purveyor of high-level professional hockey in North America. The league required its teams to sign all players to standard player contracts, identical except for salary. The team and the player negotiated salary, and if they couldn't agree, the league president, chosen by the team owners, set the salary. Starting in 1969, the league and the players' collective bargaining unit agreed to submit salary disputes to binding arbitration. The league employed a contractual reserve clause, providing that the team had the option to require a player, signed to a 1-year contract, to renew that contract with that team for up to 3 years. During that time, players thus couldn't negotiate with other NHL teams or play outside the league without their team's permission. But the teams could freely trade players amongst themselves. The league also entered into agreements with semi-professional and amateur hockey leagues. Those agreements bound players in those leagues to the NHL, giving the league control over rising players who might one day play professional hockey. The World Hockey Association began in 1971 with 10 teams, seeking to play professional-level hockey. Soon, association teams began courting NHL players, but most players couldn't sign with association teams, and when some players tried, their NHL teams, citing the reserve clause, often obtained state court restraining orders, preventing the players from moving. The association and its teams brought 5 different lawsuits against the NHL and its teams, challenging the league's monopoly over professional-level hockey players. In the lead case, the Philadelphia World Hockey Club, fielding the association's Philadelphia Blazers, sued the NHL's Philadelphia Hockey Club, commonly known as the Flyers. The association and its teams accused the NHL of violating the Sherman Act and sought a preliminary injunction prohibiting the league and its teams from enforcing the reserve clause against any player whose contract would have otherwise expired.